Why can't the members of a jury ask questions related to the case? I am a lawyer, not your lawyer. Allowing the jury to ask questions is the sole province of the trial judge. With that said, there are some issues that a juror might think interesting, which are inadmissible. Example: has the criminal defendant ever done this before? While fascinating, this might prejudice a party's right to a fair trial. Practical application: judge entertains juror questions in writing, presented to counsel for objection, and then asked by the judge. Because there is a host of rules and forms that may vary from jurisdiction to jurisdiction that govern what questions can be asked and how to ask them, all in the hopes of making the question before the jury as fact-based and unbiased as possible. Lawyers and judges are trained to formulate these questions and still get them wrong, deliberately or not, from time to time. The jury is supposed to be a seamlessly present, but arm's-length finder of fact, not an active participant stumbling its way through the rules of civil or criminal procedure. You're a layperson, and the barristers are professionals. At some point you have to believe they know what they are doing. The whole system depends on you trusting that the barristers and judges are not incompetent to the point of negligence. At least in the UK though, jurors can ask questions. I was a juror for a murder case earlier this year, and I asked a few, as did other members of the jury. We'd write a note, pass it to the judge, who reads the note out loud and consults with the barristers. Some questions were answered immediately, others were "we'll get to that later" in the proceedings. Sometimes they asked us to retire to the jury room while they discussed how to best answer the question. In some states in the US you can. The very recent Delphi murder case in Indiana had examples of this. Jurors were able to submit questions for the judge to read. They were vetted by the judge. I'm a trial lawyer. If you're in the US, jurors are allowed to ask questions. Whether they do in that particular trial and how the questions are asked is up to the trial judge who is proceeding over the trial. That being said, a lot of judges don't like to, because frequently the juror's question is about some fact or piece of evidence that was intentionally excluded because its inclusion would have been in violation of the rules of evidence. The judge doesn't want the jury to know about this and focus on it, because it could result in a mistrial, which is helpful to no one. Also, jury questions make things take 3 times as long. Personally, as a lawyer, I never found a juror's question to be particularly helpful or harmful to a case, but it was always nice when the judge let the jury ask them, because it helped me to tell what they were focusing on. Jurors can and do ask questions. Maybe it depends on the court, but I see this all the time. Source: I'm a lawyer. If the knife had fingerprints on it, the prosecution ought to have presented said evidence to the jury. If they failed to do so, they should suffer the consequences of losing their case. At least in part because the burden of proof is on the legal team to make their case. If you don't have enough information to feel comfortable finding someone guilty or responsible, that qualifies as reasonable doubt. You usually can, just not in the middle of court because it disrupts the trial. When I was on a grand jury, the judge had a court aide who would take any questions we had and pass them on to the judge, and the judge would usually come in the jury room and answer during longer breaks and recesses. In the States, they can usually ask. Best way is to write it down for the judge to review and consider. I was on a jury a few years ago, and basically we were told to write our questions and then the judge and both attorneys review them to make sure they can legally be asked. I think out of maybe 6 submitted, only 1 was allowed to be asked, which happened to be mine. I was on a grand jury and we were allowed to ask questions. Some were rather naive and the result of people watching too many cop shows on TV. The prosecutor told us this was the CSI effect, where jurors believe that a lab can enhance a reflection on car window 3 blocks away or find DNA and fingerprints on the head of pin. And if they can't, the accused must be innocent. Time is a big reason, but a lot of times juries can ask questions by writing to the judge, who then approves disapproves with input from prosecution and defense. Interestingly, something I never really thought of before my experience with court was how great effort is taken to curate the experience of jurors. We make jurors leave the room to discuss rules of evidence and procedure, so that we don't taint the jurors' views on anything. When I was on a jury during deliberation, you could ask a question. You had to write it down and the radio would in for them to take to the judge and the lawyers. When we asked to view the footage again, we got to sit on the floor and watch it. We couldn't do it during trial, which I thought was kinda silly, but what do I know? I think it's allowed sometimes. But I think the real issue is that your job as a juror isn't to get to the bottom of the crime case. It's to determine if the prosecutor has convinced you beyond a reasonable doubt that they are guilty. If there are things missing from their argument, then they didn't do their job. And those things might be left out because of legal issues. Maybe there were fingerprints on the knife, but the police didn't have a warrant, so that info is not admissible. Simply telling you they existed might bias you. I'm not a lawyer. Just throwing out my thoughts on the issue. I've always wanted to know this. In trial, it is the prosecution's job to convince the jury that someone is guilty. It is the defense's job to take what the prosecution says and convince the jury that it's possible, even in the slightest way, that the evidence used by the prosecution doesn't point directly at the accused. It is the jury's job to hear all this, and based on what is given to them, make a decision. You are not investigators, and you are not going to seek out evidence. The lawyers will do that. The jury I was on, we were allowed to write questions to the judge when we started our deliberations. They cannot reveal new facts. It can only answer facts that were already presented in the case. I know this is a different thing, but I served on a grand jury a year or so ago, and asking questions was pretty much our only job, outside of saying, yep, I think you have enough to go ahead with this case. Because some idiot would ask, do you seriously expect us to believe you didn't murder your spouse? Or other such poorly worded question.